Namaskar. We medical professionals are supposed to abide with the laws of the lands and various acts related to our medical professions. Our medical professions and the practice related to is very well guided by various laws. We have seen various acts which are actually enacted for our medical professions. How it is going to make its impact on our medical practice is the topic for today's session. So the session will be dealing with impact of legal acts on medical practice, the compliance and enforcement and various challenges related to the acts, ethical consideration in implementing such legal mandates. We are also going to discuss on various case studies on the legal acts and its applications in this session. So the various impacts on our medical practice, impact related to the regulation of the medical practice is being done by these acts. So every medical practice has got some guidelines, has to practice within the stipulated brackets of the laws, brackets of the regulations. The guidelines are there for we medical professionals to practice. That's why regularization and some regulations are there for our medical practice. We have to abide it. Also, the various acts maintains the patient's rights and their confidentiality. According to these acts, the standard care and a proper treatment, proper medical practice only has to be executed, and that will be the appropriate impact. We are also having the ethical and legal obligations because of these various acts. In cases of insurance, the insurance and its billing is also regularized by various legal acts, the insurance related acts, and we medical professionals has to take part accordingly. The compliance and the penalties also sometimes the medical professional has to face. But yes, we have to make the things as per the requirements and the proper compliance is to be met, or else penalties will be attracted. So those are the importance of the legal guidelines. In addition to the various medical research which are also guided by some laws, the ICMR guidelines. So those are also having some medical practice related impacts, and the patient care has to be properly been executed. So all those are the impacts, and those are displayed now on your screen. You can see 1 to 8 impacts what we have discussed just now. The regulations of medical practice are done by these acts. It starts from permitting any medical professionals to start their medical practice after being registered into the state medical councils of their own specialty, and the licensing and certification of their healthcare establishment will also be done. And these acts are guiding them how to practice their medicine, how to practice their profession, and accordingly only qualified professionals are permitted to do so. There are also the scope for practice, scope limited to your own specialty, the scope related to the different healthcare professions, ensuring the practitioners work within their own expertise. The patient also has got the rights and confidentiality as a part. Various laws and acts expects that whenever patients are to be undergone for some investigative procedures or medicinal procedures or therapeutic procedures, every procedure has to be done with the informed written consent. So informed consent are nothing but every details to be disclosed with the patients who is undergoing the procedure, its pros, cons, available alternatives, and the complications are to be discussed with the patients, and the consent is to be obtained from the major patient who is above the age 18 years. And written informed consent means on document you are going to take it with the signature, or if the person is illiterate, the thumb impression of the patient in presence of the other witnesses. This is the informed written consent which only stands well in the court of law if any disputes arise in a due course. But whenever the patient is approaching to you, the patient's confidentiality and the privacy should be maintained. The proper standard care is to be offered whenever the patient is approaching you for medical treatment. Wherever there is a lack of proper skill, standard care, the negligence related allegations will be attracted. The recklessness causing the harm or sometimes even the death of the patients is the negligence, and the medical professionals may be sued for the same. So offering standard care is the impact of the various laws and acts. The ethical and legal obligations are also there on the medical practice. The medical professionals are supposed to thought of ethically whenever there is a critical life-ending illness of the patient. Do not resuscitate orders only are to be obtained after the patient's next to kins and their willingness. In critical conditions, yes, saving the patient's life is the prime importance and paramount for the medical practitioners. But if the professionals knows and their relatives also knows the disease is in the critical situation and terminal stage, the do not resuscitate orders only are to be considered, but those are the ethical obligations. That's why euthanasia is not legalized in India. Though after the Shanbagh case, the passive euthanasia is considered by the court of law, and hence the do not resuscitative orders can be considered in those kind of critical and life-ending conditions. The palliative care and ensuring the ethical considerations are to be thought of. Mandatory reporting in cases where the medical professionals came across of some communicable diseases. We have faced the COVID-19 pandemic, the world pandemic we have faced. Every such detected case was mandatorily that time to be communicated to the authority. Our Indian medical professionals has done it very meticulously, and we are out of the pandemic. So this laws not only expects the medical professionals to follow the regulations, but yes, see what results it will took out of the better execution. So because of everyone's appropriate participations, we are out of the pandemic and we have faced that worldwide disaster. Yes, the abuse related or the neglect related or the mass cases also has to be reported to the authority. Medico-legal cases are to be reported to the nearest police stations, and whatever details are required to be provided to the investigating officers. In due course of the investigations, if the authority needs some further clarifications, documentations and other details can be shared with the investigating officers and the judiciary. This is called as the privileged communication. And medical professionals, though has got the confidentiality as the right of patient, but medical professionals has got this privileged communication to share their details in cases of the legal requirements. Insurances and billings are to be regulated as per the related law. Insurance regulatory authorities are there, and their laws expects that the relation between the healthcare providers, the patients, which is insurer, and the policy providers has to have in contract to provide best of the best services. The insurer, that is the patient, whenever has claim for the bill, has to be provided by the authority, maybe the hospital authorities and the insurance authorities also. In cases of any disputes, it is the right of the insurer to complain, and the redressal has to be done on priority. The fraud preventions. There are many instances which has noted that the fake claims are being made. The patient is not admitted, someone else is admitted, got operated, and the claim has been made. But if such a fraud is being detected, the claim will be denied. Even the penalties will also be attracted on the insurer part. So it is also the responsibility of the insurer not to apply for the fake claim, but simultaneously we medical professionals should not indulge in such practices wherein you are becoming the reason for applying such fake claims further. So your responsibility as per the acts is also that only when the authentic claims and the patients are admitted under insurances, you have supposed to proceed them for the claims and billing. The compliance and penalties of various acts are needed. It is mandatory to report few things, such as per the Registration of Birth and Death Act, every birth and every death in your hospital has to be registered to the authorities. If you fail, the penalties will be attracted. As per the Medical Termination of the Pregnancy Act, you have to abide the laws and regulations of 24 weeks at most, in that too in very critical situations what we discussed in earlier sessions, has to be only done wherever the violation of those regulations are found. The medical professionals will be attracting the penalties because they are not complying with the guidelines. So adhering to the various regulations is must. Non-compliance will be penalized by means of fines, by means of suspensions of license, maybe temporarily or sometimes permanently, and revocation sometimes are the various acts, various actions which can be taken against the medical professionals. The medical research is also considered to be the part of our medical practice. Our medical profession is fastly changing. The new area has got the emerging trends, the emerging diseases rather, and various modalities as a part of treatment available, including the investigating techniques also. So research is also becoming part and parcel of our medical profession. That's why if someone wants to adopt the medical research in their practice, you have to abide the ICMR guidelines and the ethical guidelines stated by those statutory bodies. And in that conditions, either in clinical trials or in other related medical practices, the protection of the rights of the participant should be at the prime center, and the integrity of the research is based on those values only. Regulatory approvals are needed for various trials, various research to innovate the new drugs, to start the new modality of treatment, but for that purposes regulatory approvals are needed. Even the medical devices are also launched, but only after abiding the laws of the research related acts. The patient has got impact in terms of health for all. It is the basic right for every citizens to have the health related access to the individuals, the treatment, the prevention in terms of vaccinations are some of the modalities as a part of their access to care is the basic right, and this is the impact of various laws and act. Not only the access but quality access is also mandatory. So quality wise care should be provided to the every individuals. Then compliance and enforcement challenges also lies with the medical insurances. The regulatory compliance is that the Insurance Act of India, which is of the British rule 1938, it was enacted by the Insurance Regulatory and Developmental Authority of India, and this Insurance Act rather got amended at various point of time because it was found that there is necessity of amending it by various sections, by various means, by various guidelines. So those amendments were made in 1940, 41, 46, 50, 55, even in 1968, and after a long gap of almost 40 years, then it was further amended in 2002, 2015 and 2021. So such amendments were made related to the Insurance Act, and it has got 120 sections and the 8 schedules under which the various Indian companies, how they can provide the insurance related policies, what role will be there, the healthcare providers role and the regulatory authorities role. In cases of any grievances, what should be the mechanism of redressal also is made available through these amendments. The key challenges are its complexities of regulations. Yes, because it is difficult to adopt and implement and follow each and every regulation, but one has to read it, understand it and practice it to have the better practice free from any allegation. There are some transparency issue also. Policyholder should have every details clear and transparent with him before him when he or she is actually going to have that product. The fraud prevention also is one of the challenge because many frauds are actually coming forward and the fake claims are noted, but those remains the challenge, and it is the regulation which only has reduced it significantly, and accordingly the fraud prevention remains the challenge which the guidelines and acts has done very well. The data is lying with the policy offering companies, but the protection of the data of the insurer, the public, is the prime challenge remains with the policy companies. And in an era of digitalization, hacking of the data related to the medical insurance and the insurer's details to be protected properly, or else It is the breach of the contract and breach of the confidentiality. Information technology and the personal data protection billing has role to play related to this. Information Technology Act states that the strict privacy laws are there and legal recognitions of electronic records to be done, facilitation of the electronic governance and commerce, promotion of IT sector growth and cybercrime regulation. The main key points of the Information Technology Act are displayed on your screen, which has got these key features. In addition to that, the Personal Data Protection Bill is also there, which expects that the patients, the insurers and any individual's data should not be leaked out, should not be breached, should not be shared with anyone else, anyone authorized bodies. Wherever such thing happen which violates the basic of the Personal Data Protection Bill, it was enacted in the 2023 and the collection of such data online or offline is digitalized, which further is to be saved properly, or else the proper safeguard lines are to be issued to the authority protecting it, or those will be then having the penalties if not done properly. Company has to have the social media firms voluntary verification process of the users, so that the users will first verified and then only will be offered the access. Sharing the data without the consent sometimes may attract the fine, which may extend up to 15 crores. And data breach is also one of the fear, and that has to be prevented. So such things are mandatorily to be done in favor of the patients and their benefits. The enforcement of the Insurance Regulatory and Development Authority of India is the prime body and is responsible for enforcing the regulations. It expects the compliance from every stakeholders in every kind of insurance, may it be the general, may it be the health, may it be the group insurance. So such insurance products are to be regularized by the IRDA's DAI policies, and that enforcement has got some challenges because there are some constraints for the authority to implement it, because they have got a limited resources of manpowers, and to monitor such a big over every individuals, over every city and places and every state, it's certainly difficult task, but the proper implementation and a supervision to be made with those limited resources. Evolving the regulations from time to time, we have seen how many times the amendments were made. It is because every time new issues are coming up, and with those emerging issues, the authority has to have some proper regulation in future to combat for. So with a proper implementation, proper amendments, the issues can be resolved, and those are the challenges for evolving issues. So regulations will be keep evolving in terms of their amendments. The penalties and legal resources are the another challenges, because the insurer or sometimes the policy providing companies will also be approaching, and the redressal of such complaints is the complex procedure and even time consuming, but though it is a challenge, has to be smoothly done in terms of ombudsman's help in terms of the authority officials or sometimes forums and civil courts even. So the functions of the Indian Regulatory Developmental Authority of India are displayed on your screen, and those are the various regulations to control and to keep a regulatory watch on the insurance industry. Insurance industry is every stakeholder's involvement, so that from policy preparation, the policy document preparation, the policy product formation, its marketing, its purchase by the insurer, the adopting those policies, and whenever the need is there, they are availing it and then claiming for the benefits. So ultimate aim of such insurance is to settle down the claim. Every watch is being kept by the authority on such process, and that has to be done meticulously. Interest of the policyholder remains at the center, and which is to be protected well. Every citizen, every family, every group of employees should be insured. No one knows when the adversities are coming into happenings. To avoid such happenings, the insurance remains the ultimate solution. May it be the medical insurance, may it be the group insurance, may it be the public insurance. Even we have also came across of some car insurance, property insurances, and this kind of insurances are giving us the protection in terms of its monetary loss. The compensation either will be made in the monetary supports. So promotion is being made by the authority. There are regulations for every insurance product, as we discussed. All regulations varies with product to product. Keeping monitoring and supervising watch on the process of the insurance. If any complaints are being raised, any allegations are being made, any grievances are being raised, the appropriate redressal within a stipulated period remains the another functions. Regulations of the reinsurance is the function. Enforcement and penalties. Whenever any stakeholders is not abiding with, may it be the company providing, may it be the hospital establishment claiming for the cashless bills, or may it be the insurer, whoever is not abiding may attract the penalties, and it is the function of the authority to penalize the faulty persons. Even the international collaborations are expected through various means, and those can be done with the contracts, with the understandings for the betterment and for the better product to be provided to the insurer. There are some ethical considerations in implementing the legal mandates. So ethically, patient's autonomy should be at the center. The informed consent and disclosure about the process has to be done perfectly, or else you are keeping the person in dark. And with such incomplete information, patient later on may claim that everything is not being disclosed. And it is also unethical on our part not to disclose the entire things. Balancing profitability and patient cares is the another mandate. Insurers face the ethical dilemma of balancing profitability with providing comprehensive coverages. The legal mandate may require coverage for certain conditions, but the insurer may seek to minimize payouts, potentially leading to ethical conflicts. The confidentiality and data protection is the another mandate. Every data is to be very well maintained, protected. Otherwise, the breach of the confidentiality will be penalized. Equitable access to the insurance for the product which is being sold to two different individual and to a society. Every such insurer should be equally provided with the benefits. The conflict of the interest also lies there. The insurer and the healthcare provider may face ethical issues related to conflicts of the interest when recommending the treatment or procedure that may or may not be fully covered by the insurance. We are going to have the case studies related with legal act applications in medical insurances. The Health Insurance Portability and Accountability Act violation and the ALCA Health System 2011. We have also taken the cases from other countries so as to make you aware that not only India but the other insurance industry of the other countries also face the problems. The background is ALCA Health System employees were found to have improperly accessed to the medical records. Medical records of Britney Spears and Maria Shriver was accessed without their authorization. So, legal act in this case states that such case which mandates the protection of the data of any insurer and their confidentiality handling remains with the company. But here the ALCA Health System was at fault. The outcome of this case was in terms of compensation to be paid in a huge amount to the insurer. The Health Insurance Portability and Accountability Act states that the data of every individuals has to be protected, and it is the privacy rule. The Affordable Care Act and its impact on coverage denial. This case is about a patient with pre-existing condition was initially denied coverage by an insurance company after the implementation of Affordable Care Act, which prohibits insurer from denying coverage based on the pre-existing conditions. The patient was able to secure insurance cover. Legally, the Act states that it is significantly reshaped and healthcare landscapes in those countries like US by expanding the access to the insurance and setting standard for the coverage. The outcome of this case was impact on reducing the coverage denials for individuals with pre-existing conditions and ensuring the broader access to necessary health services. The pre-existing conditions means when the insurer is purchasing some policy product, and if any medical conditions, health conditions were also initially present before opting for those products, it is called as pre-existing condition. Those and related treatment management only will be covered after lapse of some duration and not immediately starts after the purchase of that policy product. It's all depend on the conditions and regulations of the policy providing companies which close it into the policy documents. But such denials are reduced as per the Affordable Care Act. End-to-end life care of one case is there. Terry Shiva woman in a persistent vegetative state become the center of prolonged legal battle between her husband, who wanted to remove her feeding tube, and her parents, who wanted to keep her alive. So parents were in favor of keeping the feeding tube, but because it was a continuous vegetative state, her husband wanted to remove it. The legal act states various guidelines like the guardianships of the laws, and the Patient Self-Determination Act, which gives patients the right to make decisions about their own health care. So, outcome of such conditions as per the law, after numerous court battles, the feeding tube was removed. The Schiavo passed away in 2005. The case was brought national attention to issue end to life care, the legal rights of the patients and their families, and the ethical dilemma faced by the health providers. So, such patient self-determination acts in the Western countries also has got the patient's autonomy. The case study of the Emergency Medical Treatment and Labor Act and the Burdett versus US Department of Health and the Human Services. The background of this case, Dr. Burdett was fined for refusing to treatment a woman in active labor and instead transferring her to another hospital without proper stabilization, which resulted in a lawsuit under the Emergency Medical Treatment and Labor Act. See, in Western countries also it do happen that the patients in critical conditions are being referred without attending them, without providing them the primary care. Such an act requires the patients to be admitted, to be attended, to provide the emergency medical treatment, and regardless of their citizenship, legal status or ability to pay, they should be attended. Before transferring them to the another center, they have to get stabilized. The outcome of this case was the doctor attending the case was fined. The case reinforced the importance of compliance by the attending doctor as per the Emergency Medical Treatment and Labor Act. The case study related with Indian Regulatory Development Authority of India versus Bajaj Allianz Life Insurance Company of India, wherein the scenario was the Bajaj Alliance faced the allegation of mis-selling the insurance policy, not disclosing the entire conditions and regulations of the policy with the customer. The Insurance Act 1938 mandates clear communications and the transparency in policy selling. But here the Bajaj Alliance fails to do so. The outcome of this case was IRDAI imposes a fine on Bajaj Alliance and the company was directed to improve its sales practices, highlighting the importance of compliance with the legal mandate and insurance marketing. So, the IRDA imposes a penalty of 3 crore 10 lakh on the Bajaj Allianz Life Insurance for violating that rules. So, such an actions the authority is free to take. Various acts imposes that any individuals or uncorporated body of individuals or a body corporate under the law of any control under the law of the country should have the product of the policy. The insurance acts are made mandatory for various companies to adopt the various guidelines stated. The another case study is related with Vimal Singh versus National Insurance Company, the denial of coverage. Vimal Singh's claim was denied by National Insurance on the ground of pre-existing condition. Singh contended that the condition was not pre-existing and filed a case. The Consumer Protection Act 2019 allows for grievances to be addressed in consumer acts and the consumer forums. The court ruled in favor of Singh's, ordering the insurance company to pay the claim with interest. The case emphasizes the need of fair treatment and adherence to the legal standards. These are the various insurance companies and the various product of national insurance seen on your screen. So as we stated, there are various products of the insurances, including the medical insurance, that is health insurance, and other insurance. But if they are not disclosing the conditions and the terms and condition of those policies, they may attract the penalties. Consumer Protection Act has got the key implementation in terms of right to safety, right to information, right to choice for the patients, right for the consumer education, in cases of any grievances to seek the redressal, and whenever they will approach for any consultations, they have to be heard, either it to be the ombudsman or to be the forums or to be the law. Case studies of Manipal Hospital versus IRDAI. The patient at Manipal Hospital was denied cashless treatment by their insurer due to an alleged not network hospital status. Network hospital status means the hospitals which are empaneled with the company to provide the cashless benefits. Hospital has to register with the company, and after the all requirements, maybe in terms of specialist wise, the insurance company will be empaneling and then providing the services to their insurer. In such cases, in this case, it was found that the Manipal Hospital was not empaneled and was not network hospital in that situation. IRDA intervened, ensuring the hospital's network status was honored and the patients received the promised cashless service there. This case highlighted the enforcement of network agreements and the patient's right under the insurance policy. So, as per the guidelines, the cashless hospital services are to be streamlined and regularized, which later on did meticulously. The guidelines ensure policyholder to access the medical treatment without having any payouts from the pocket at the time of service. So, interactive discussions on the future trend can also be there. So, we can have some kind of thought, self-directed learning in cases how this digital transformation is going to affect the insurance industry. Digitalization is there. Everyone has got every access on their cell phone itself. We medical professionals are also recording pre-authorization, recording the consent, sometimes in video recording kind of modalities, intra-op, post-op, all photographs are to be obtained, to be taken. So, those changes are being seen. You are also going to witness in when you are going to practice the situation. So, personalized insurances plans are available. You can check the earlier sessions for the details. There are varieties of insurance products and accordingly their terms conditions varies. Integration of preventive care remains the prime importance. Regulatory harmonization is important for the better outcome. Increased consumer protections remains at the center, may it be the regulatory authorities, may it be the Consumer Protection Act, or may it be the ethical guidelines of the medical profession. So, sustainability and the ethical insurance is the ultimate aim of the insurance related acts. So, with this session, we can see the various future trends which are expected, because the data hacking is the challenge remains with the digitalization. It can be hacked through your cell phone, through your net services, or from the servers and clouds even. So blockchain's securities remains the options, data management and the proper telemedicine with a legal framework. Within the legal framework remains the challenge in coming days. Cyber security and the data protection is also important. The personalized insurance plans are available. Those are shown on your screen now. Regulatory harmonization, the medical practice and insurance product becomes more globalized, and on your screen you can see how it has to be harmonized. But yes, there are some challenges which remains there in adopting those harmonization steps. Consumer protections, day by day the consumers are getting aware about their rights, and it is the need. They should be aware about their rights, and in cases of any damages, the injuries, and abiding the law, when the violation of the law is being made, it has to be the right of the patients to approach to the dispute redressal committees. And the sustainability and the ethical insurance is the prime product. On your screen you can see how it has to be done. Consumer driven health plans are available, and accordingly the whether insurer balance provides the flexible options or not, and what likely to be potential risks and benefits in the consumer driver health plans are available. The impact of climate change is also there on the health insurance. How insurers prepare the health impacts on climate change, new products or the services might emerge in response to the climate related risk. The ethical and social consideration is equity in coverage and access to the care. What ethical guidelines should be established for the use of personal health data? In future technologies and innovations, the relationship between the healthcare providers, the patients and insurers technologically should get matched, should be free from any insecurities like hacking. In an era of virtual reality and health monitoring and the security wise, the health record should be maintained, and innovations on the horizons could be redefined the insurance industries. So with such an session, hope you have came across of the various impacts of the laws and acts related to the medical insurance. Thank you so much.